Hello everyone, this is Sachin Sawant, your UK immigration lawyer. Today, the statement of changes has been published. I'm just looking at the rules and the explanatory memorandum for the changes to the dependent rules for the two job codes, care workers and senior care workers. So the job codes are, so till now it was only in the news, there was a fact sheet declared. Now the rules have been published and they will be added to the immigration rules and they will become live from 11th of March 2024 job codes that are affected. So this does not affect all skilled worker applications. So remember that I'm getting a lot of questions on the channel about different types of skilled worker visas on different job codes. This change of dependents not allowed, husband, wife, partner, children under 18 years of age. So those they are dependents. They are not allowed only if anyone is sponsored in the skilled worker visa for these two job codes. So it is 6145 and 6146. 6145 is care worker, 6146 is senior care worker. If your job code on the certificate of sponsorship is one of these, only then this video applies to you, only then the changes apply to you. Very important. Yes, so this is what has been written. I have already made previous videos on the basis of the fact sheet and that whatever information we got from Home Office. Now this is the final version. This is the immigration rules that will be added into the rules and they will become live from 11th of March onwards. We'll discuss about transitory provisions first. Any new applications after that date, after 11th March, will anyways be affected with this change. But mainly, I will talk about the transitional provisions because many individuals are already in the UK on the skilled worker visa or they've already applied. They are in between somewhere. So the applications are not going to be filed after 11th March, but any applications filed before 11th of March when the rules change, that is under the current rules. So this is what the Home Office has said. Who have applied on the route and are sponsored in these occupation codes 6145 and 6146 before these changes come into force. So these changes will come into force on 11th of March. Let's say you applied latest by 10th of March. I think usually the rules change by 12 p.m. in the night, so 12 a.m. in the night. So before by 11:59 p.m. on 10th of March, if you do submit the application, then you still come under. Yeah, but don't keep it till the last moment. Yeah, sometimes the IHS website or something may not work. There is one more additional change that has been brought along with that is in future only CQC registered regulated companies can sponsor these two job codes, care workers, senior care workers, 6145, 6146. Only CQC regulated, Care Quality Commission. So that's a regulatory body for these care homes and all. So previously that was not the case. Even if the companies were not registered, they were able to sponsor. So that change is also coming to play. So first I will deal with this small part. If you are currently working or you are being sponsored by a non-CQC registered company which is not registered, you will have to continue working for them only. You will not be able to switch into another non-CQC employer. If you want to switch employers, you will have to get a CQC registered employer who is willing to sponsor you and then change employer. That is very important. Second part, someone who is already working for a CQC regulated person. So the CQC thing only comes into play when you are changing employers. So let's say you are working for an employer who is not registered with the CQC, you can continue working with them till the time your visa is valid. So that is fine. But at any point you come to the end of the visa and you have to extend it for whatever reason. Let's say you have under 5 years of visa, you have only 3 years visa, 2 years visa, anything under 5 years that doesn't qualify you for ILR. So in order to complete the 5 years, you will have to switch to another employer. So the another employer should be CQC registered. That's very simple about the CQC part. Now someone who is now we'll just deal with anyone who is already working for a CQC registered employer. They can continue working for the same employer, they can change employers. Everyone can do this, not whether non-CQC or the CQC one. But if you are with a non-CQC employer, you can only change to a CQC employer after the rules change on 11th of March 2024. You can continue working till your visa is valid, or anytime you can change employers. You can also settle, apply for indefinite leave to remain. So for any employees who are already sponsored by, so let's say the date of application is 10th of March latest, if you have already applied under the previous rule and it is a valid application, so I know all those areas where people will come up with questions, my DCOS is not approved, all of this I will apply before by 10th of March, but I will give the DCOS subsequently on 10th of April or whatever that is. Those are that may there are various situations to that, but I'm talking of a straightforward application where individual already has a DCOS that is approved and has a valid skilled worker application. They file 10th of March or earlier, then they can be joined by dependents. Either dependents can apply with them or subsequently dependents can join, either husband, wife, partner, children under 18 years of age. So even if the main applicant changes job from your current employer to another employer and you want your dependents to join later on, they can be joined. Since you entered the rules, this is how the rules apply. Since you entered the skilled worker area with these job codes on or before 10th of March, that is, you made a valid application. A valid application needs an approved DCOS as well. That is a part of the validity requirement. Very straightforward applications I'm talking of now. I will get into the other sides also. Then you can continue to sponsor. Either you can bring along with you or you can subsequently be joined, whether with the same employer or even if you change employers, you can attach your dependents at a later stage. Rules don't talk about the DCOS is not approved and all of that. The rules are only covering a valid application. A valid application is where you have a valid and assigned DCOS, approved and assigned DCOS, and you have made a valid skilled worker application. So only when these two conditions are satisfied, then the application is valid, and the rules will only talk about that. It will not talk about any of those holding of skilled worker applications, decisions pending and all of that. So basically, if it is a valid application, then you are sorted. You can bring your dependents along with you. You are not affected. You can change employers, then bring dependents, or your dependents can continue. All of you can qualify for ILR. You come under the current rules, not under the new rules of dependents not being allowed. And I will repeat this. This only applies to these two job codes. 6145 is the job code for care workers and 6146 senior care worker. Only these two job codes. If you are in some other job code, let's say chef 1234, business development manager 4567, whatever that is, so these changes don't apply. All the normal dependent rules apply to you. Dependents are allowed across the board on all skilled worker job codes except these two only, and these two will be implemented on 11th of March onwards, 11th March 2024 onwards. Coming to the applications which are, I know there will be questions around if you file the applications without a DCOS, you can ask them to hold it and all of that, but those will be at the discretion of Home Office. The rules don't provide anything about that. The rules strictly say an application is valid only if you give a valid DCOS, which is assigned and which is valid. DCOS is not valid unless it has been allocated by Home Office and assigned to the applicant. So that's how it works. So anyone who is waiting for those DCOSs, defined certificate of sponsorships or undefined certificate of sponsorship, even if you are switching inside the UK, then these rules don't provide anything. It will be at the discretion of the caseworker. Let's say you file the application on 10th of March latest, 11th March the rules change, you get your UCOS or DCOS, undefined cost or defined cost later on, and then you submit it. It will be at the discretion of the caseworker. They may reject it upfront when they get it, saying that there is no valid cost along with this, whether U or DCOS, and they may reject it back to you. That's the end of it. There is nothing doing. That is what the immigration rules say that the caseworker would ideally, that's what the immigration rules authorize the caseworker to do. But in the past, where situations have been different, I know lawyers try, we have also done successfully where an applicant's, let's say any other leave is expiring. Let's say they have a skilled worker leave, they want to change employer, they are a student, their leave is expiring, they are on a graduate route, their leave is expiring, whatever is the reason. Inside UK, yes, we have tested all of this. Outside UK, this will be very challenging. I think it's very less probability that outside UK you file an application and it will be kept on hold just for the sake of DCOS, which is pending. We will just have to see how Home Office is dealing with all this, but you have to risk your fees. IHS has already increased to 1035, visa fees, etc., etc. No doubt you get a refund if it is refused, but you lose the visa fees and all of that. So yes, that is what you're taking the risk of applying an application without a certificate of sponsorship. It's your decision. We will have to see how Home Office caseworkers deal with such situations. But under normal circumstances, If everything is valid, TCOS is valid, application is valid, your current rules apply to you. Dependents can be joined either along with the main applicant, you can accompany, or join subsequently, either with the same employer or even if you change employers later on. So these rules are published now. They will be, yeah, so they are already published, is the statement of changes that I'm looking at. So it is final now. So earlier it was only in the news and in the fact sheet. Now it is becoming a part of the rules, and these rules will become active on that date, 11th March 2024. And if you do like this video or want to watch any of such videos, do subscribe to our channel. There are many informational videos about new entrant, visas, graduate switching, skilled worker, salary increase, all of that, and along with these ones also, dependents. So I have made this video especially today because the rules have been published. I just got that email, this email about 1 or 2 hours ago now, from the UK government's website that I have the alert set up on, and yeah, I read it and I'm trying to analyze it. So these are the final rules now, so there is nothing new, there is nothing to interpret or guesswork doing. Earlier in my videos I was only predicting what is going to happen with on the basis of the fact sheet, but whatever the Home Office had stated in the fact sheets and all, that's what they have exactly drafted in the rules. That's what they've done, and this is the first time anyone is looking at the rules now. So, and thank you very much. Do subscribe to our channel if you like this video. Like, ask your comments. There are several live sessions. Become a member if you want to become a paid member. There are many options to get engaged and support this channel. Thank you very much.